In this segment, I want to talk about the civil rights movement post-World War II through the late 1950s. And so we'll take it from the Brown v. Board decision through to the Little Rock crisis. Now, just a bit of a reminder here that much by 1954, when the Brown decision comes down, much had already taken place in the United States. It's improper, I think, to consider or think of the civil rights movement as starting in the 1950s or starting with Brown. And in a previous segment, I tried to make that case. And I want you to remember that groups like the NAACP were actively working through legal channels to challenge the segregation and the inequality that existed in the United States, and predominantly, remember, had focused their efforts on professional education, graduate work, and graduate schools. It's also worthwhile to remember and contextualize the civil rights movement in terms of the Cold War. Remember that the Cold War was not just a battle of the Soviet Union and the US, but it was seen as a battle of ideology, of worldviews. And one element of that was a notion of human rights, that the United States was better at protecting human rights. It had that tradition of the rhetoric of liberty and freedom and that mission of the city on a hill. Understand how difficult it becomes to make that argument worldwide to people in Africa or Asia, in the third world in particular, that the United States upholds these values when it's clear here domestically, here in the U.S., that African Americans and other people, in fact, are being treated as second-class citizens, are being denied some very basic human liberties. So automatically, this issue of civil rights is caught up in the Cold War fervor, and you can sort of, I think you can begin to see that as you look to Harry Truman in particular. And Truman, remember, in the late 1940s begins to act as no other president really had done since Reconstruction, to actively promote desegregation. Not only had he created his Commission on Civil Rights that really set the agenda for the federal government over the next 20 years, but in 1948, he uses his executive powers to desegregate the U.S. military. And just a few years before, during World War II, in fact, blood that was donated for the wounded and for casualties, blood was segregated under the U.S. military. You had segregated units in the military. By the time you get to Korea, think about it, 1950 to 1953, by the time you get to Korea, you have integrated units. And so the United States military actually leads the way in this drive for greater equality and, frankly, desegregation. But we look to Brown, and Brown is an important decision of the Supreme Court. In 1954, the court rendered a decision that would essentially strike down the 1896 decision of the court, the precedent of the court, in Plessy versus Ferguson. And we talked about that one a little bit earlier. Now, if you remember, in Plessy, just as a kind of review here, in Plessy, the court had determined that separate treatment, so long as it was not unequal treatment, was acceptable under the Constitution. Homer Plessy had wanted to ride in a particular car for which he'd bought a ticket, but was denied that opportunity, and he sued, claiming that his rights as a citizen of the United States had been trampled upon, simply because of race. And the court said, that's okay, so long as the treatment is equal. That little bit, that little connection is what makes Brown so important. There are some things you want to understand about Brown. First of all, it's not simply one case, because the full title will be Brown versus Board of Education of Topeka, Kansas. But it's not just Topeka. It's a number of scattered cases around the country A number of these cases, though, had a kind of common theme, and it involved distance. And I just want to speak to this very briefly. It was not uncommon for African American students, or other students for that matter, there's a Hispanic element of this case, but it's not uncommon for African American students, for instance, there's a good example in South Carolina, and of course there's a similar one in Topeka, to have to go further, to endure more duress to get to school than white children would have to endure. In Topeka, for instance, it was a matter of having to walk or travel about a mile to get to an African American designated school, and during the walk you're bypassing a much closer white school to do it. There's no reason other than race why the African American child should not be able to attend that closer white school. That was the argument of the parents. For one thing, if you're a parent, you understand, how much more dangerous it can be the further a child has to travel. In South Carolina, for instance, it's a notion of distance around a body of water and busing, school buses, and transportation not necessarily being readily available. So in essence, in the most dire circumstances, you're making it much more difficult for one group of people, one group of children, and we're talking about children here, one group of children to get an education. And if we all value education, it's difficult to find any way to defend that unless one holds in one's mind certain ideas about race. And the lack of necessity for providing education, public education, for particular children. So the Brown case goes through the courts and it comes to the Supreme Court, and they render their decision then in 1954. The Chief Justice of the Supreme Court had been the previous governor of California, nominated and approved under Eisenhower, and formerly had been a Republican. The same governor who had been involved with the internment of Japanese citizens from California during the Second World War. The thought was, by the way, his name was Earl Warren. I guess I should throw that in. But the thought was that Warren, because he was a Republican and a Republican nominee, would be relatively conservative in his judicial views on the court. It turned out to be quite different. And in fact, Warren will play an integral role in leading the court in the Brown decision to a unanimous decision that reverses court precedent. The NAACP had decided by the late 1940s to shift away from this total focus on sort of professional education and graduate education to looking at K-12, kindergarten through 12th grade. The argument that's made by lawyers no less than Thurgood Marshall and the lawyers of the NAACP will be that separate treatment is inherently unequal. That what separation produces, not merely in practice, not merely in practical terms, but in theoretical, abstract terms, that the very idea of separation imbues the group that is separated out with a sense of inferiority. In other words, and I always try to do it this way, kind of personalize it. But if you put yourself in the position of a parent or a child of elementary school age, you can imagine that a child coming home from school one day can't help but notice that he or she goes further to school, that it's more difficult to get to school, but perhaps can't help but notice that their school is not of the same quality. The building's not the same, the grounds aren't kept the same, and the fact is, it was often the case that, most often the case, that per pupil expenditures simply were lower, much lower, for African Americans, say in the South, than they were for white children in public schools. But you can imagine this child coming home one day and asking a parent, what's wrong with me? You know. And anytime you see a child suffer that way and start asking those kind of questions, you all know as well as I do how difficult that can be. We know as adults that the world's not always fair, but it's awfully hard to see a child experience that kind of unfairness in their own lives. Well, that's the argument, ultimately, that the NAACP made. And it's the argument that swayed the Warren Court. They determined that the educational policies of the various states involved, and more broadly of many school systems in the United States, were inherently unequal and contrary to the 14th Amendment, which guaranteed equal rights of citizenship. Education was the responsibility of state and of the federal government. And they went to the point of saying that even if equal facilities were provided, the very act of separating people based on race, being exclusionary, was unacceptable under the language of the Constitution in the 14th Amendment. It's not dissimilar from someone in the law school. We talked about the cases earlier about law and education. You know, part of a college education is making contacts. It's networking. It's getting to know people who later on may be useful as you move up professionally. And if you're segregated, if you're excluded from those relationships or the possibility of having those relationships, then you are at a severe disadvantage as you move forward in life. And that's the basic idea of the Brown decision. The question, though, is what do you do about it? The Supreme Court has the power to actually force governmental entities to undertake certain actions of correction, as well as private entities. But a year later, the court came out with sort of the second Brown decision, or a caveat to the Brown decision, having to do with enforcement. And there's an interesting phrase that's used in this court order, effectively, that called for the desegregation of American schools. The issue is one of time. How long do you have? Does it need to be now? Does it need to be later? And this goes back to the whole civil rights question. It goes back to Reconstruction. It goes back to Frederick Douglass. When is enough enough? William Lloyd Garrison. When, if something is mine by right, how long should I have to wait to have it? If it's mine by right, ought I not to have it now? That's the question. The court's answer to this question of, well, when must desegregation be completed? That answer was to use the phrase, with all deliberate speed, which is a vague phrase. And what that does is open the door for resistance. In other words, the court didn't say, by next Tuesday, you must desegregate. Now, desegregate. The court, I think, sought to allow school systems to develop plans for a timely but reasonable sort of desegregation in the court's view. But ultimately, they ended up opening the door to allow segregationists, those who wanted to keep the education system segregated, allowing them to stall, to draw out the process just as long as they could, because every day they could hold it off was another day you had segregation. Eisenhower wasn't overly active. Remember how he had worked behind the scenes with Joseph McCarthy to sort of undermine McCarthy. He refuses to speak out in support of the court's decision. He refuses to undertake policy or overt action that would encourage or even force school systems to act quickly. In the interim, we see the emergence or the reemergence of a revived Ku Klux Klan. And we know about the Klan from the Reconstruction and from the 20s, and here the Klan emerges again in the 1950s in a major way, as many working class whites in particular seek to use threats and violence and other means to stop this process of desegregation. But we also see the emergence of something called the White Citizens Councils. And these White Citizens Councils sprang up across the South and really different parts of the nation. The White Citizens Council is known as the Uptown Klan. They basically wanted the same things, but there was a desire to dissociate the Citizens Councils from the Klan and what the Klan represented. The language is different. The White Citizens Councils occasionally, you'll hear talk of race outright, but you'll often hear that talk couched in other terms. And I want to be very, very careful here because it's accurate, but it's not total, what I'm saying. And what I mean by that is the White Citizens Council might speak in terms of federal authority and the relationship of the national government to the state, and they might talk about such things as states' rights as well as race. Now, granted, the issue of states' rights is still alive. There are still issues of federal organization and structure in our Constitution. Certain powers are designated to the states, others to the federal government. But I think it's clear from the historical record that you began to see a linkage between these terms, certainly by the 1950s, in the rhetoric of the White Citizens Councils. The express purpose of these councils and ultimately of the Klan was to prevent this process of desegregation, both in education and more broadly in society, from going forward. We also see in the 1950s an exodus from the public schools as white parents, rather than see their children attend school with kids of other races, chose to pull them out of school and put them in private schools. So what we end up with is not a clear decision on the issue of segregation. Rather, we end up with a decision on segregation, but an issue of enforcement that almost lends itself to holding out, to expanding the process just as long as you can, extending it as long as you can. And of course, that leads to a great deal of strife over the next decade or two.